Prosecutors are corrupt and biased and use their power to destroy people's lives. That is what I would have told you about prosecutors about 2 months ago if you asked. Now, I see things a bit differently. Hello everyone, my name is Zoee Edmonds and this is the Power in the Courts podcast. Today, I want to have a conversation about the court system. More specifically, I want to talk about the role of the prosecutor and what power prosecutors hold in their roles. My goal today is to help you as my listener better understand the role of the prosecutor and how their role plays a larger part in our justice system. The question we are trying to answer today is how does the power of a prosecutor yield a capacity for bias and discretion to play a role in the courts? I want to take a second to describe for those who do not know what a prosecutor does. A prosecutor, as Cornell Law School describes, is a lawyer who initiates prosecution of a criminal offense and presents the case for prosecution in a criminal proceeding. The official name for the position of a state prosecutor is a district attorney. This is important to note because the two experts we will be hearing from shortly work or worked in the district attorney's office. Prosecutors work for the community and decide to prosecute cases they deem worthy. When we hear from the attorneys later and they decide how cases are decided, I do want to note that there are guidelines for sentencing that we will not really discuss, just to show there are some stipulations. As Schaefer 2023 describes, prosecutors are empowered to enhance, reduce, or diminish a defendant's charge, and critically are not required to accept the initial charge chosen by the arresting officer. Studying prosecutors is important to understanding greater issues within the criminal justice system. Barkow 2013 describes how the federal prison population has increased 400% at a steady rate nearly 3 times that of the states. And whenever the benefits of presidential administration, the consequences of prosecutorial administration should concern anyone interested in a rational criminal justice regime that is free from bias in any particular direction. These concepts of bias in prosecutors go hand in hand in current research. Joy 2009 describes how the justice system is more concerned with avoiding conviction of the innocent than it is with assuring conviction of the guilty. This goes beyond trying to know if prosecutors are good or bad actors. Starting this project, I had the false perception that prosecutors had great desire to alter the court system and would use their inherent bias to push their own political agenda. However, I have come to realize through the conversations you're about to hear that prosecutors hold such immense power in their positions, so my curiosity changed from questioning discretion to questioning how the role of a prosecutor allows them to yield so much power that people think they are biased. How can we, the people, give prosecutors so much power in their positions that you could perceive wrongdoing? That is what we are going to be observing today. So starting as early as 2007, I have found sources referring to prosecutorial bias in our system. Burke 2007 says, increased attention to the possibility that unintentional cognitive biases can play at least a large role in wrongful convictions as intentional prosecutorial misconduct. Then, Hasbrock 2021 says, at the beginning of a criminal case, the prosecutor has enormous discretion to decide whether to charge the defendant, and if so, with what crimes. Because the crime charged often carries a mandatory minimum sentence, the prosecutor has a basically unreviewable power to decide how much or how little the punishment the defendant may face. Even judicial tools for granting shorter sentences are subject to prosecutorial control. These sources and the ideas of power and discretion largely led my research and distracted me from my original interest in the power of prosecutors. I say this as to show you my perspective and to acknowledge current research before I give my take. If you would like to further look into any of these sources, you can find the references in the description. This was the part of my research where I have started to gather a new perspective. With all of that, I now want to jump right into the 2 interviews I had with 2 very different attorneys. For the sake of keeping their identities anonymous, we are going to call Attorney 1 John and Attorney 2 Peter. John has been a prosecutor since he started his legal career. Peter, on the other hand, has gone between prosecution and defense and now works primarily in defense. To start, I asked John about the role of the prosecutor and which crimes are more important to prosecute than others. This is what he said.
What cases that we prosecute. That really, for the most part, 98% probably of the cases it's determined by the police or whoever the law enforcement entity is who's investigating the case and filing the charges, they're the ones who conduct the initial investigation. They're the ones who bring charges. Now, they'll sometimes consult with us, on different legal issues along the way, ask if there's enough evidence to support different charges, and things like that. But ultimately, when we're deciding which charges to prosecute, which cases to prosecute, number one, you have to look at, is there enough evidence to support a criminal charge? If there's not, then you're pretty much done right there. You're not going to move forward on something that doesn't have evidence to support it. And then if there is enough evidence to charge, then you look at other factors to decide, well, which crimes are we going to charge? Does it make sense to give this particular defendant some sort of consideration for various reasons? Some defendants, maybe they're cooperating with law enforcement on a larger investigation, and so that might entitle them, or at least make it advisable to go easier on them with their charges, or give them some sort of consideration in sentencing. Or if they've taken the initiative to start getting some sort of counseling or treatment, or they've already paid back the victim, if it was a theft type case, if they've kind of admitted what they did was wrong, and they've already taken steps to make amends, then that'll factor into how we determine what an appropriate punishment or what an appropriate outcome would be.
Before we hear the rest of what John says, I want to point out, for those who do not know, in criminal justice we use the UCR, which stands for the Uniform Crime Report, to collect and track crime reports and statistics across the nation. There are two offense types, Part 1 and Part 2 crimes. Part 1 crimes are murder, rape, theft, robbery, assault with a deadly weapon, and things like that, whereas Part 2 crimes are forgery, fraud, vandalism, and you can find more on this through the FBI UCR website. Let's get right back to John and hear what crimes he focuses on.
I think crimes that have victims who have experienced the greatest harm, so let's say violent felonies, armed robberies, stabbings, shootings, homicides, and then crimes that cause trauma, mental trauma as well, child abuse, sexual abuse, those type of crimes. I think it's important to try to get those resolved as quickly as we can and prosecuted through the system as quickly as we can, because the victims and the families of the victims in those cases they're really in need of a just outcome, and it's going to have a huge impact on their lives. Victims of other types of crimes, not that those crimes aren't important, but if, things like theft, maybe somebody's the victim of a forgery or things like that, those, again, we want to try to move every case as quickly as we can through the system, but the impact on the victim isn't quite the same.
Okay, so I want to stop here and mention a few things that John said there. Firstly, he mentioned the role of the prosecutor, and I looked to Pollock 2022, where she says, police and prosecutors often work together to build a case. The problem with this is prosecutors are supposed to be a due check process to make sure the evidence is sufficient to go forward. This goes right along with what John just said. The prosecutor's role is to check on police and to balance out the power given to police to ensure justice is being served. This idea is critical to understand the role of the prosecutor. Their critical decision-making ensures justice. With that idea, I want to discuss how education plays a role in the power of the prosecutor. Attorneys go to law school for 3 years, then need to pass the bar. Does this education play a role in their moral decision-making when it comes to choosing cases? Looking to Burke 2007 again, they say, some empirical evidence suggests that education can potentially mitigate bias, especially if the education focuses on the cognitive processes that lead to bias. So, if evidence says that education can improve biases in decision making, do we look to attorneys to make decisions due to their education or their position of power? What ethical standpoint do you think our two experts have? As you listen, what do you think? One might say they have a utilitarianism stance where they do the greatest good for the greatest number, or a stance of egoism where they do what is best for themselves, or maybe even they stand on the ethics of care where empathy and care lead their morals. So let's get right back to hearing from the experts. We're now going to hear from John and then Peter about why they chose prosecution or defense.
Most of the cases I handle right now are violent felonies, so homicides or other violent felonies. For me, at this, when I started out, of course, you don't have a choice. You handle whatever cases are put on your desk, and we end up doing um, a little bit of everything at that point, and you kind of gradually work your way through and gravitate towards certain types of cases more than others that you're either interest you or you're more suited to prosecute. So for me, the homicides and the violent crimes, violent felonies, I've kind of focused more on those at this point in my career just because they are the ones that have the biggest impact, the ones that I think cause the most harm to society as well as the victims and the victims' families. And so we have to make sure that those cases are handled properly. Of course, we want to handle every case properly, but it's just important to make sure we do everything correctly on those. And there's a huge feeling of satisfaction, I think, when you can do a good job on that type of case and get justice for victims who've really experienced horrific events.
Now that we heard John's perspective, let's hear from Peter.
If I could go back and do it all over, I enjoy a lot of aspects of what I do. There's some aspects of what I do that I really don't like, but I like to help people. I like to solve problems. Whether it's a parentified child syndrome from growing up in the house that I grew up in, I have a need to be a fixer. I have a need to fix things for people and help people out. And I want to do the right thing. So I guess I ended up exactly where I'm supposed to.
As they just described, their passions led them to their specific fields of interest. And if you are unaware, there are way more professions that can come out of a law degree than just a prosecutor or a defense attorney. Hader 2014 describes the various jobs that can come from a law degree, those being Attorney General or State Attorney's Office, plaintiff attorney, defense attorney, staff attorney, litigators who advise clients in and out of court, trial attorneys who argue facts, appellate attorneys who argue the law, and non-trial attorneys, also called transactional lawyers, office practice lawyers, corporate lawyers, or attorney advisors, who seldom need to go to court. There is so much to a career in law that precedes a job as a prosecutor or defense attorney. With that, this shows the true passion prosecutors must have for this line of work. Many lawyers do not need to go to court or step foot in a courtroom, so those who do must enjoy the work they do. With that, let's get back to the attorneys and hear more about what side of the courtroom they are on. They both spoke about why they picked what they did, and now we are going to hear about why they have the passion they do. You are now going to hear from John first when he was specifically asked where the passion for prosecution came from.
Yeah, I think it's a great question and a fair question, because a lot of people they decide that they are interested in criminal law, and so they know they want to do something in criminal law, but they're not really sure which side. And there's definite value in both sides. I'm not one who's going to say that there's anything negative about criminal defense attorneys. They're a very important part of the process. You have to have representation for defendants. But for me personally, um, to me, my focus is on the protection of the community, safety, helping law enforcement do their job. They're out there risking themselves for the community, and trying to hold people accountable who are doing harm to others. And so that's kind of where my satisfaction is in the job. And the thing I think that would I would have a lot of trouble dealing with if I were on the defense side is the better you get at the job, and let's say you're in a trial and you do a really good job, well, the outcome to me could be that justice is actually not served. If I do a better job than the other attorney, um, I get a win, quote unquote, for my client. That may mean a dangerous person goes back on the street who shouldn't be on the streets, a murderer, a rapist, someone who harms children or harmed, did harm to children, those types of things. And so yes, they're entitled to their constitutional right to a defense, but it's not going to be me doing it. I just don't, that would not carry a lot of job satisfaction for me.
Now you're going to hear from Peter, who has a different take.
Your past forms who you are now, and life experience forms your approach to the world. And one of the greatest things that can happen for purposes of being involved in the law is that you have experience on both sides, because it gives you an appreciation for the two sides of the case. When you do prosecutions, you want to make sure that you have evidence to go forward with, and you do the best you can to make sure that people are protected, and that that you have the right person before you go forward with the charges. And if you develop evidence after that that says you don't have the right person, then you have to cut them loose.
I want to pause for a moment and discuss the concept of winning. We're going back to Poly 2022, where she says something I want to note here. She says the prosecutor's goal is justice, which should imply an objective pursuit of the truth. However, we know that sometimes the only goal seems to be winning. I say this because John mentioned being too good can cause justice to not be served, which goes directly to the role of the prosecutor to ensure justice is served. I think this balance we have between John and Peter truly exemplifies the role of the prosecutor. This proves the position impacts the lives of people more than it does the record of wins for a prosecutor. With that, and the topic of choice and impact, I want to discuss bias. Bias, as defined by Cornell Law School, is to exhibit a pre-existing inclination or prejudice for or against someone or something. Bias, in the case of a prosecutor, could refer to the decision to prosecute or not prosecute a case based on personal ideology. Now we are going to hear from John on his thoughts on bias.
Most people, I would hope, don't make decisions based on any sort of internal biases. I think, I'm answering the question starting from the premise that everybody has some level of internal bias, so one way or another. But I think especially as time goes on, doing this job for years and years and years, there's no type of person in the community who deserves any less protection of the law than anybody else. And so I don't think that any decisions that I make are driven by any kind of bias towards any particular group or individual. We have to take every case and every defendant on the specific facts of that case and the specific circumstances of the people who are involved, and make our decisions based on that. And you really just realize the longer that you just live as a human being, but in particular doing this kind of work where you see what we see on a regular basis, most stereotypes about people aren't really right anyway, and they're not a fair reason to make decisions. And so, crime is kind of an equalizer. Everybody can be a victim of crime at any given time. And anybody who is in that unfortunate position deserves the same consideration, when we're deciding how to handle the case, as do the people who commit those crimes.
Now let's hear from Peter.
Because we carry the baggage of our lives with us. And I think a failure to identify the fact that you have an internal bias is a failure to um, recognize the realities of the situation. Because, we all the internal bias is something you have to fight against. The internal bias is something you have to understand that it exists and get past it. Because if you don't, it may lead to bad decision making.
While we have heard from our two attorneys, a little note I want to leave you with is Shavs and Maths 2019 found that the district attorney's characteristics, more than the characteristics of a courtroom or a county, is more likely to impact the perceptions of justice received, and the characteristics of those two attorneys we just heard are very different. Does this change how you perceive them? I think something we as people need to better understand is, instead of just the need for prosecutorial fairness and lack of bias, don't we also need prosecutorial transparency? We need to know how decisions are made and why they, the prosecutors, are making the choices they are. From Fortier 2019, they say prosecutorial transparency is an essential step in ending mass incarceration policies that have locked up millions of people, ripping them away from their families and shattering neighborhoods across the nation while deepening racial injustices. It is imperative to collect and analyze information on how prosecutors contribute to these harms in order to hold them accountable and to design solutions to reverse this nationwide crisis. Now that we have heard lengthy details about prosecutors' thoughts on the role of the prosecutor and the power that we the people give them in the role, it is important to clarify what we have learned. Critical choices prosecutors make and checks on other departments are two ways prosecutors produce justice. Prosecutors have immense power that comes from the people they protect in their positions. Then with that, they protect people and protect justice. While it is significant in their positions to have discretion, prosecutors enforce justice through their compliance and passion for the job. While there are guidelines and education requirements to be in this position, prosecutors choose their positions and their role is critical to the justice system. As you know, this is called the Power in the Courts podcast, yet we barely scratch the surface of the power that prosecutors yield. We talked immensely on their role of the prosecutor and how their role impacts the justice system. Their power, however, comes from the burden the prosecution holds on the courts. The prosecution is essential to ensuring justice is served, and as John said, that the communities are protected. So we the people give power to the prosecutors to ensure that they protect us in their positions. Prosecutors hold immense power in the courts brought by the people. While that is fine, should they hold less power in a system that was designed to give them the most power? Should there be more stipulations about which cases to prosecute? What is the line between law and opinion, and where does their discretion play a part in serving justice? If they get to choose which cases to push through and which to not, how does that impact us, the people who give them the power? Is it too much power to give individuals? Is there too much of a burden placed on prosecutors? If all prosecutors are like John and Peter and they hold high moral standards, is that enough to ensure justice? Can a prosecutor ever truly do the greatest good for the greatest amount of people? Can they ever let empathy guide their morals? That is for you to decide. Now that I have told you what I thought and what I have learned in the conversations in between, what's your perspective? Do prosecutors use their ethical standpoints to make decisions fairly? Or do they have so much power that it is inevitable they use it for their own motives? Is our court system fair in the power that is granted? And are the actors good and fair, or is it all a ruse? To end, I want to hear from Peter one last time.
You've got to protect people. Whether you're on the prosecution or defense side, you have to protect people. And if you don't protect people, then there's no business being in this line of work.